He also did a warranty deed,
And
so I'm not exactly sure.
what was the date that was filed with the auditor?
I have, getting older, let me put these fancy web boys on. 4/29. And the reason being is because I didn't have the money to file the paperwork.
Okay.
I am a single mom and it's just Marley and I.
Did Ms. Radecki, did you receive that?
So, Your Honor, I received some deed from her. I don't recall if that was the date. I can check my inbox though. But there was nothing to do with her name, to the best of my recollection, on it, nor Mr. Jackson's
Okay.
interest conveyed to Miss Kanata.
Okay. So it sounds like we're ready to move forward then. So Ms. Radecki, this is your motion, so I'll turn it over to you. And then Ms. Quinata, you will have the option and ability to respond.
Sure.
Okay, go ahead, Ms. Radecki.
Thank you, Your Honors. Plaintiff is Annette Jackson. We're seeking a preliminary injunction and a writ of ejectment today, so that my client can get her home back. In Washington, courts that assess a three-part test generally when trying to assess whether a preliminary injunction is appropriate. Those three prongs is, does the person have clear right to possession? Is there a well-grounded fear or invasion of that right? And then the third one is is there continued injury resulting from defendant's unlawful occupancy? So ultimately, the relief that we are requesting today is immediate removal of defendants and any unauthorized occupants, in order prohibiting the defendants from taking, damaging, moving, or selling any of plaintiff's property, restoration of any personal property that's already been taken or damaged, and then authorization.
Buckle up, because this isn't your average courtroom squabble. It's the tale of a so-called Karen who decided that property law doesn't apply to her. Imagine this. Your ex loses a house in a divorce. You swoop in, plant yourself there, and then spin sovereign citizen flavored fantasies to justify staying. That's exactly what's happening here. We've got fake deeds, bogus legal claims, and a judge who is running out of patience. Over the course of 2 hearings, you'll see the courtroom strategy unfold. And spoiler, it's
pursuant to a final divorce decree entered on August 26, 2024 in Cowlitz County. The cause number was 23-002-4408. That was attached as Exhibit D to our complaint. Defendants have never had a valid lease agreement, never had paid rent or a legal right to reside on the premises. The defendants had submitted a lease agreement. They purported it was valid, but it was not issued by Ms. Jackson, the plaintiff. It was not signed by her. Ultimately, they are not tenants. The defendants entered the premises without plaintiff's knowledge or consent after she was forced to leave the home due to domestic violence. RCW 7.28 supports plaintiff's legal right to possession as the record and sole title holder and the only legal owner to the property. Defendants don't assert any valid ownership rights or tenancy. They were at best holdover licensees, but now have been trespassers since they were served with the proper notice to vacate back in February of 2025. So moving on to the next factor, the well-founded fear of immediate invasion of the rights. Defendants remain in unlawful possession and continue inviting strangers onto the property. Law enforcement frequently visits the property. Plaintiff had visited the home in December of 2024 with law enforcement and discovered a number of concerning things, but especially highlighting missing personal property. Her dogs were locked inside the house without food or water, and there was just general.
It's not much of a strategy at all. The plaintiff's lawyer will hit hard with the law, while our Karen tries to argue adverse possession and even throws in some sovereign citizen paperwork for good measure. By the end, this isn't just a property dispute. It's a masterclass in how bad legal theories collapse under actual law. Stick with me, because the twists, the contradictions, and the sheer audacity will leave your jaw on the floor. Notice what she's doing here, flooding the record with paperwork she barely understands. She mentions a roommate release, a quick claim deed, and even a warranty deed. But here's the kicker. None of those filings actually give her legal ownership of the property. It's classic pseudo-lawyering. Throw enough terms around and hope one of them sticks. Judges see through this immediately. The real problem is that while she's busy playing paperwork lawyer, the actual legal owner is footing the bill, paying rent somewhere else, and worrying about property damage. It's not just nonsense. It's costly nonsense. What do you think? Intentional fraud, or just someone way out of her depth?
Disrepair and suspicious activity occurring inside the home. The continued occupation of the defendants prevents plaintiff from accessing, maintaining, or safeguarding her property, and has violated her rights as a property owner. So moving on to the third and final factor regarding the actual and substantial injury to the plaintiff. There has been ongoing economic and personal harm that the plaintiff, Ms. Jackson, has suffered from the inability to reside in her home. She's had to incur additional financial expenses to house herself elsewhere in the interim. Property has been missing, gone damaged inside her home, the property that's subject of the action. She does have concerns about the well-being and welfare of her animals and other personal property that she's not been able to observe in the past 6 months. And this has caused her a great deal of emotional distress, and she has safety concerns about the property and welfare of everything there. Defendant's presence is causing continued deterioration and damages, and plaintiff is concerned about further damages if the preliminary injunction is not granted today. At this point, these injuries, a lot of them are irreparable and not compensable solely with monetary damages. So regarding the balance of equities, just to touch on that for the courts may weigh hardship when considering a preliminary injunction, but only for innocent parties generally. The defendants were warned of their status as trespassers and received a 3-day notice to quit on or about February 8th of 2025, but failed to vacate and clearly still occupied the premises. They knowingly remain without rights to do so, and Ms. Jackson is entitled to
This is where the case really sharpens. The plaintiff's lawyer lays out exactly why this isn't an eviction. It's an ejectment. That's an important distinction. Eviction is for tenants with a lease. Ejectment is for squatters, trespassers, or, let's be blunt, onto people who have no right to be there. It's like trying to kick out someone who broke into your Airbnb and refuses to leave. The lawyer methodically ticks off the legal boxes: clear ownership, ongoing harm, and irreparable damage. By the book, the plaintiff should win this hands down. But court isn't just about the law. It's also about how much nonsense the judge has to endure before making the ruling. And here's the emotional punch.
Recover her property back and eject the defendant immediately without further delay. Plaintiff's hardship, loss of access to the property, damage to personal possessions, possibly her animals, and an inability to exercise ownership rights far outweighs any minimal inconvenience to the defendants at this point. They've had well over 3 months of notice to vacate and have still failed to do so or show any indication that that's their intention. At this point, we believe that the injunctive relief is appropriate as plaintiff has clearly satisfied all 3 factors: the clear legal right to possession as the sole owner, that she does have a well-grounded fear and immediate invasion of that right. There's continued injury resulting from defendant's unlawful occupancy of the premises. And courts may act to preserve the status quo and to prevent loss or damage during litigation. So we're requesting the courts to grant this preliminary injunction, to grant the order ejecting the defendants from further damage. And I did want to touch too on the bond requirement for Court Rule 65B. So it does require a bond unless it's waived. We would just simply request that the court waive the bond, but if the court is inclined to issue one, that it would be a minimal bond of just $100, due to the 2 main factors of there's a lack of lawful claim or tenancy of ownership or ownership by the defendants. There's no credible risk of this being a wrongful action at this point. And also we would reiterate a request for fees and costs associated with this action. So to sum up, we are just requesting that the court grant the order for the preliminary injunction, ejecting the defendants from the property immediately.
We're not just talking property lines and paperwork anymore. We're talking about real damage, real costs, and even neglected animals. The plaintiff has been locked out of her own home, forced to find other housing, and lost pets in the process. That's devastating. Meanwhile, the squatter paints herself as a single mom just trying to get by. But let's be clear, personal struggles don't give anyone the right to hijack another person's house. Judges weigh hardship, sure.
Possession. I know that you're not doing this without an attorney, but typically
Right.
adverse possession does require quite a lengthy period of open, notorious, hostile use. So if you want to start there, feel free.
Sure.
Go ahead.
Okay. Um, first thing I want to say with the adverse possession, I've had to fix the furnace. I've had to fix everything on the maintenance, on the maintenance side of that. I already mentioned that Matthew's not there. It's just me and my son. And I kind of took some notes a little bit, but basically I've been there for almost 3 years, going on 3 years. I don't know how long she's lived there. When Eleazar left, and I'm not part of their divorce case, so whatever property she had went with Eleazar, and whatever property she had went with her. So I don't have any of her property. The other thing is, ADT will verify that they never came and served me. And so I actually put up ADT systems because there were people that were coming to the house, and it was just Marley and I. And so I do have that. And then I also have that I was reaching out to her, and I posted notices, hey, what's going on? And that's verifiable through Woodland Police Department, because they had taken some reports and had said, we seen a notice on the door, and they actually verified that there wasn't public notice on the door and on the street side, so that she could see, hey, this is what I'm doing. Where do I pay my rent? What do I do? So I started that, I think, in September, after or whenever their divorce was. I started reaching out to her, and all I got was, well, I talked to, I always forget his name, the mayor of Woodland. Anyways, I was talking with him, and I said, is there a reason why all this is going on? And he said, well, she still owns.
But the scales tip heavily toward the rightful owner when one side has been following the law and the other side is inventing their own. So at this point, the lawyer has essentially served up the case on a silver platter for the judge. Clear ownership, repeated trespassing, property damage, and a mountain of evidence that screams, time to go.
The house, I go, I know, but I'm just trying to communicate with him. So he knows about the situation too. And then I also spoke with my son's advocate through missing and exploited children. I've been talking with her about it because Annette had installed cameras at the house, and that's why we ended up getting ADT. So I do have everything that is verifiable through Woodland Police Department, the mayor of Woodland, and through ADT, that I was never been served. I've never even received a notice saying, hey, new ownership. I've never received any of that. The only thing I received was an ejection. I was like, what is an ejection? I've never heard of it. So I had to do a little bit of research, and I understand what it is, but I'm not a squatter. I'm actually on a lease. I signed it with Eleazar. And I'm kind of glad I did, because that's how it started, was, that we were roommates, and then it went into this whole big thing, and I've been dragged into their divorce for no reason. I mean, I get and I understand, but I'm not part of that case. The case like today is just about the house. I'm on a lease. There was an adverse possession because I kept trying to reach out to her and put posting notices, and I didn't know how to contact her. Then after that, what else was going on? Basically, that's pretty much it. I mean, and then I said, and then that's right. I got a foreclosure notice on the door, and I was like, oh my gosh, what's going on? And so then I actually submitted the information to the mortgage company saying, hey, I'm right here. What can we do? And I filed and submitted a 1099A with them. And then that's when I asked Eleazar, he said
Oh, if this were a boxing match, the plaintiff just landed a perfect combo. But remember, this is where our Karen gets her turn at the mic. And if you thought the legal argument was airtight, wait until you hear how she tries to wiggle out of it. Spoiler, it involves buzzwords, half-truths, and a crash course in sovereign citizen logic. This is where courtroom patience gets tested to its limits.